Being an entertainment attorney means I do a lot of intellectual property law work. So much of what is on the internet, not even close to what you need in order to protect yourself. The copyright ownership, who owns what you're creating? And there's a misnomer out there that if you pay for something, you own it. It's not accurate under copyright law. Well, okay, so first and foremost, the reason I'm here is because I'm an entertainment attorney and predominantly music, and my background is in music. I am the mermaid lawyer because I am a mermaid.
Interesting. So what's the story behind that?
Well, I'm a child of water. I grew up swimming competitively. I've always loved mermaids, and everyone who's known me throughout my life has known that about me. I've been a mermaid for Halloween. I can't even tell countless of times. Um, Both of my children were born in the water. I had mermaid-themed baby showers,
Wow.
all sorts of different mermaid things in my life. And after I'd already been practicing law for about 10 years, I've been practicing since 2009. I had my kids and, I work in the arts, but I grew up in the arts. I myself am a creative and I needed some kind of a creative outlet. Once you have law practice and then you have kids, you're very busy. And so I just needed something. And I started putting kids and adults in mermaid tales on the side on weekends just to give myself a little joy on the side. And that ended up turning into performing as a mermaid. And I started performing at high-end events all throughout South Florida. I was on Deco Drive and Channel 10 and started getting a lot of attention as a mermaid. And a lot of my colleagues started to worry because they were seeing all these mermaid. They're like, you're an attorney, but we're seeing all these mermaid posts. What's happening?
That's great.
And so to make a long story short, my website was about 10 years old at that point, and I was due for a refresh. And I decided to marry the lawyer with the mermaid and became the Mermaid Lawyer. And I have a registered trademark. And if you go to my website, you'll see a lot of me as a mermaid on my website. And it's something that's resonated with a lot of my clients who are also creatives and has been just, it's been very joyful for me and helped me to connect more with my clients and attract the type of clients that I like. So that's how it came about.
So that's your spin on marketing, right?
Yeah, that was just, I wanted to do something unique and fun, and that's my branding.
That's very interesting. So obviously there's a creative side to it. Obviously, everybody in the world of music, film, entertainment, they have a brand, but a lot of times they don't take the necessary steps to protect their brand or even come up with a strategy. You're a lawyer. So for all the creatives in the world who will watch this in the audience, where do you start? Where does that independent artist or independent filmmaker or creative or musician start?
Okay, so being an entertainment attorney means I do a lot of intellectual property law work. What that means is trademarks, filing copyrights, litigating trademark and copyright infringement matters, and then contracts as well. And so when you are coming up with your brand, it's really important to ensure that you're coming up with something that's very unique and distinctive. Distinctive is a term in trademark law that in order for you to have a trademark, it has to be distinctive. So it can't be like anyone else's, and it certainly can't be confusingly similar to anyone else's, or else you'll have issues. The first thing that I would recommend, and I also recommend my clients, is do a search, see what else is out there. Make sure that whatever it is that you're choosing is not already in use or something that's confusingly similar. But even before you do that, choosing something that is I think representative of you and authentic to you. The Mermaid Lawyer is something that is who I am. And it's very easy for me. I feel like I'm being authentic because that's, what everybody knows of me. So choosing something that you can market yourself honestly, easily, authentically, and then do that search. And there's attorneys that perform trademark searches for a fee. They usually use third-party search companies, but just see what else is out there. And then if you really, this is the one that you chose, it's still a gamble no matter what, but at least you're going into it making an informed decision, knowing you're not going to have any obstacles um, in the registration process. It's like a 9-month long process before you even have an examiner assigned in the USPTO, which is where you would file for a federal trademark. So, in that time, you're already going to start spending money marketing, and God forbid you get an office action back, 2D refusal for likelihood of consumer confusion with a prior filed or registered mark. So that would be my first recommendation is, choose something that's authentic and distinctive, and then make sure nobody else is already using it.
So that is, I guess, the start of creating your brand from the legal perspective. But
Yeah.
there's so many different steps to it when you actually start building your brand. Like, for example, people have podcasts, people create events, people do art, people have intellectual property.
Mm-hmm.
So what's the next layer to that? Like, how do you start to protect yourself, including when you start working with people? Because that's another aspect of thing.
So yeah, I mean, obviously, when we're creating our brand and creating all of our works of authorship, we are probably collaborating with others. And that brings up issues of copyright ownership. Who owns what you're creating? And there's a misnomer out there that if you pay for something, you own it. And that's not accurate under copyright law. And by the way, just a little disclaimer, I'm giving some legal tips. Do not take them as legal advice. I'm a lawyer. I'm not your lawyer until you hire me. You sign an engagement agreement. But this is just sort of general tips for you to think about. And if you are creating, I highly recommend hiring an attorney to make sure you have the proper paperwork in place so that you can secure your rights. If you are paying somebody to create something for you, like a producer or a graphic artist or a website designer or a photographer, they are the creators of that intellectual property. Even though you paid them, they actually own the copyright in that, unless there is either a work for hire agreement signed in advance, agreeing that it's a work for hire and that the person hiring them is actually the author and owner of the copyright, or a copyright assignment agreement after the fact, assigning over the copyrights in that work. It's critical, and what can happen is if you don't have those agreements in place, is those people could actually have leverage to stop you from using the work that you've paid for. So it's really important to have those agreements in place with your collaborators so that you have full freedom to do what you wish with the works that you're creating.
But in all of that, you just mentioned something is important to have a lawyer, to work with a lawyer, especially with all the creation that's going on in today's world. But not everybody can afford a lawyer. So how does one get a lawyer? But two, what other resources are out there? Maybe if they can't hire the best entertainment lawyer out there, well, what are the resources that are alternatives they can use to, start that process?
You're not going to like my answer. So, so much of what is on the internet is not even close to fulfilling what you need in order to protect yourself. So much of it is inaccurate. There is legal aid, but entertainment law, intellectual property law, it is a specialized area of law, and it is a complex area of law. So um, I don't have any alternatives for you other than hire an experienced attorney that practices predominantly, if not only, intellectual property law, because it is so complex and it is so easy to screw up. And if you have help from the internet or forms that you found on the internet or
What about
someone
chat?
who's not, huh?
What about AI?
Oh, well, so we're going to start talking about AI. So AI is a wonderful tool to help, I think, be more efficient and create things. But from a legal standpoint, I I'll just give you a personal story. So I spoke at a conference and I was trying to find somebody who could pull some motions and some pleadings in a case that was in New York. And I do a lot of federal work, but this was cases in New York State, so I didn't have access to their database. So I did a little chat GBT to give me some summaries of what had gone on in the case. And so, I was just sort of prepping myself as I was trying to find someone to be able to pull these cases for me. And once I actually got the pleadings and the motions and started reading them, what ChatGPT was telling me was going on in these cases was not accurate at all, because what it was doing is it was scraping from just articles that were written on the internet by people who interpreted it incorrectly. And so it ended up being worthless for me. And ChatGPT just it pulls from other things already on the internet. And so much of what is on the internet, especially about music and music contracts and intellectual property, it's either not telling the full story or it's just flat out wrong or it's antiquated. So I would not rely on ChatGPT because you're most likely going to screw up and not accomplish what you're hoping to accomplish, which is securing your rights correctly.
Wow.
Sorry.
I mean, everybody uses it, but I guess not
I
100%.
wouldn't use it for legal advice. I mean, it's helpful. Like if I'm trying to create a post for social media and I put in prompts like, "Hey, this is kind of like what I want to write about," and can you just like make it sound better? Then it's helpful in that respect. Or hey, can you help polish my email? This is what I want to say, but make it sound a little bit better and fix my punctuation. It could be helpful for that, but not for building contracts, not for legal advice. I wouldn't use it to create anything because AI is a machine and you can't file for copyright registration in a work that is created by a machine. So if you're using AI to write songs, um, you you actually the Copyright Office has a compendium that says that part of the song that the machine created is not copyrightable. So when you go to register it, you actually have to exclude out the portion that was generated by the AI, and you have to make clear like what your input was and then what the output was that is being excluded. And it's a very great area of law still, but I wouldn't do it because you're diminishing your value if you can't own the copyright in it, because then you have no recourse. You need to have a copyright registration in order to sue someone for copyright infringement. That's a prerequisite to filing suit. And if you don't have a valid copyright, then there goes your case, and that, you know, then you have no recourse to stop someone from ripping you off.
So, I mean, you just mentioned about music, but what about beyond the music or just the brand assets that we all create? And now everything is going to be created through AI. So, like, for example, if I create graphics for my brand and I want to use that, I want to monetize that, what are the risks to using AI for your brand?
Because it's a machine and you can't own the copyrights in it. And if somebody rips off your graphics, then you have no recourse.
So
I mean, you could maybe create a graphic that's going to be your stylized logo that you use and get a trademark on that if that's a source indicator for your brand. But from a copyright standpoint, you're going to have issues
mm,
if you want to stop others from using it. Yeah, but again, if you file a trademark in it, then you at least potentially have recourse that way if you're using it as a trademark or a logo at
so
your
so
brand.
so interestingly, AI and AI avatars are going to be, or they're already here, and that's going to continue to be a big thing in the sphere of the digital world. How does that play into that?
Avatars?
Yeah. So, for example, I could take a picture of you or a video of you, and then clone yourself, and then
Okay, so we're talking about publicity rights issues now.
yes.
Okay. You're like throwing me a little softball. Okay, so yeah, publicity rights issues are definitely something that are a concern when it comes to AI. Um, that is a state law thing. That's not a federal law thing. So there are some states that are cracking down on use of AI um, to violate somebody's publicity rights. The thing that you can do to minimize that is, well, there's some creative methods. I would say first and foremost, anybody who's like, let's say, for example, a photographer that you've hired to create that photograph, unless it's a selfie that you took yourself. So, like we talked about from a copyright standpoint, the photographer owns it unless there's a work for hire. They've assigned over the copyrights. A lot of photographers don't want to give up their rights in the photographs that they've taken. So, you can put restrictive language in the agreement with the photographer that says, I'm not granting you, even though photographer, you're still going to own it. You're giving me a unlimited exclusive license to use it for X, Y, and Z, or a license to use it for this, but you, photographer, are restricted from licensing it to third parties or sub-licensing it to third parties. You're restricted from creating derivative works out of that photograph, and that could, you're restricted from, pushing it through AI platforms, something along those lines to prohibit it from getting out there by the photographer. Now anybody can see that photograph online and use it. So that's why if it's an important photograph to you, I'd want to have the copyright in that photograph. So, when you pay a photographer, see if you can get those copyrights. Otherwise, they're going to be the ones who are filing that copyright infringement claim. If a picture ends up being used and it's like a derivative work, it's not considered transformative or fair use. So you stop them from a copyright standpoint, from a publicity rights standpoint. If somebody's commercially using your name, image, likeness, there are laws, state laws that give you a cause of action in the event that that's infringed. But it's tough unless you're a celebrity and you regularly license out your publicity rights for a fee. The damages are based on like the fair market value of the use. So if you're just like Joe Schmo and you've never really, licensed out your image before, that it's hard to get substantial damages for that. Some people are going so far as to creating a very detailed, stylized design and maybe filing a trademark for it, but you'd have to actually be using it in connection with goods and services. That might be another method. But there are state legislators that are trying to add to their publicity rights statutes to prohibit AI usages of publicity rights, and that's how we can crack down on it. But it's still in the new stages.
So it's a gray area.
I mean, it's just technology has been evolving at a rapid pace, and the laws can't keep up with it fast enough. So hopefully, there's a lot of people that are, trying to make things happen in their states.
So what are other ways in terms of the evolving market that we're in to protect yourself, or at least protect yourself from any new type of technology or changes that are happening right now?
Well, so one, I would just be careful what you're feeding AI, because you're giving it content that it can then, base new generations off of. So if there's something that you don't want to have possibly used, I wouldn't feed it into ChatGPT. That would be my recommendation. And I'm talking from like photograph standpoint. The filing your copyrights and your works, because then you have recourse to stop it if there's an infringement. Like send a cease and desist or do a takedown notice on the platform that you see the image being used or the work being used. Same thing for music. If you have that copyright registration, then they're going to listen to you. But if you don't, they usually, if you file a takedown notice, usually they want to know the copyright registration number. And if you don't have that, then the likelihood that the platform is going to do a takedown is decreased.
So how would you know your work is increased? Because a lot of the AI is being are derivative works of compilations of many different, maybe even thousands of produced into one work, for example.
Like mashups. Well,
Yeah.
so a At that point, is it transformative? Because under the copyright law, there's defenses to copyright infringement, and one of them is fair use, like the transformative fair use. So if it's like a mashup where it combines, multiple different types of works and it's sort of transformed into something else, or if it's a parody, then you might not have a cause. It just depends on the type of use you're referring to.
Right.
So I register those copyrights, you guys. It actually gives you a chance. And then if you do, and the infringement occurs after, then you get statutory damages and attorney's fees. If you don't, and you register it afterwards, you're only eligible for actual damages. And that's a lot more costly to try to prove, because then you need to get experts, and copyright infringement litigation is expensive. So you definitely want to get your attorney's fees if you prevail in a lawsuit, because those could exceed your damages.
So is there any other types of advice that we haven't spoken about here today that creatives should take, especially the independent creatives?
There are a lot of things that you have to budget for, pay for as an artist. Being an artist is expensive. Budget for an attorney. I can't emphasize that enough, because too often, sadly, I get people that come to me after the fact and we're trying to fix things that arose because they didn't secure their rights, or they didn't understand their contracts, they didn't have things filed in advance, and it's an uphill battle if you don't do it on the front end right away. So that's my advice. And then just make sure you have those contracts, you guys. I know it's hard when you're collaborating with friends and you think everything's all like kumbaya, and then exciting things start happening and money starts flowing in, and then things go sideways. And if you don't have a contract in place, it can get really nasty. So
On that thought, though, what type of contract should artists use when they're collaborating?
well, so it depends on who you're talking about, who you're collaborating with. So if you're collaborating with a co-songwriter, just make it clear what the splits are, what the creative contributions are. Is one person going to be the sole copyright owner? Are you going to jointly own the copyright? And then if you're collaborating with a producer, there's a couple issues, because it's the sound recording copyright and then it's the musical composition copyright. Is your producer still going to be a co-writer along with you and whoever else you've hired as a lyricist? And then are they going to be giving up their copyright in the sound recording? Hopefully, yes, because otherwise it's going to make it harder if you get an offer by label. We've got a producer who is a co-owner of the copyright. It makes it hard for the artist to give up their rights to the label, which typically they require unless it's just a distribution deal. They usually want to have your copyrights, so that they have the exclusive right to distribute them. So it's hard to do that if your producer is out here and still has a piece of it. So yeah, proper producer agreements that have the proper language in them, which you cannot find those online that will deal with everything that you need. Do not do that. Featured artist agreements with anybody who might be singing on the song and co-writing on the song, making sure that they, if you've just hired them, they don't own rights in it as well. Because the more people that have their hand in it, just the more likely it is that you are handcuffed and the project's not going to go very far, because people are going to, create problems for you. So it's good if it's your project, you own the rights in it, then you can do whatever you want with it. But the only way you're going to be able to do that is if you have work for hire, copyright type assignment agreements in place with them, and also establishing what the royalties are, the accounting provisions, all that good stuff.
How easy is it to copyright?
Oh,
What's the process? I don't.
That's a wonderful question. And this is actually something that I tell my clients, I'm happy for you to just pay me for 30 minutes, an hour to teach you how to do it. But I don't want you wasting your money on me filing all your copyrights, because that could get really expensive. And this is something that you could do if you know how to do it correctly. And it's not one of those complicated songs that is like a derivative work of a pre-existing song and has like samples in it. So, because then I would recommend having an attorney help you deal with that, because there's clearances that need to happen. But so the United States Copyright Office has a website. It's copyright.gov, and they have an e-filing portal, and you'll have to register to have your own account through the e-filing portal. and which is really annoying because they make you, I don't know if you have your own, they make you change your password every like couple of months, and they make it be some ridiculous combination of, it's so silly, but it's kind of antiquated, but they do that to keep it secure. And you log on, and it's actually a pretty straightforward application. The thing that gets a little confusing for people is when they ask you, is this a work for hire or not? So you have to understand what that means. And typically, if you have a work for hire agreement, then you would say yes, because then it'll designate you as the author, even if you weren't the author. And so that's like companies who hire people to create works for them, that it would apply there. But same thing for if you hire someone to create a work and it's one of those work for hire works under the Copyright Act, you could do that. So once you understand how to do that, then it's just a matter of filling out the authors and then who the copyright claimants are, who contributed to what, the addresses, and the creation year, the publication date. If it's published, you can also file for copyright even if it hasn't been published yet. But it's important to get it done as soon as possible after you've published it. Published it means like it's being made available for public, it's being made public essentially. And if you don't do it within a certain amount of time, usually I think it's 90 days, then you are disqualifying yourself from statutory damages and attorney's fees if an infringement occurs after that. So do it as soon as possible. And yeah. And so if,
How much does it cost?
oh, so the base filing fee for if you're a company that is filing as a author, then it's 65. I think if you're an individual and you're the sole author and claimant, then it's 45 still. But it's rare that I have clients that are just the sole author and owner. Usually they have a company, like a loan out company. So it's like per work, it's 65. But there's also different fees depending on if it's like a compilation, a collective work. It kind of depends on what you're filing. But yeah, also in the filing process, you get to select what type of work it is. So if it's a work of the performing arts, like a musical composition, or if it's a sound recording, or if it's a literary work, or a graphic work. So, all of those things. And they have pretty good guides on how to do it. But usually my clients are like, just show me, like I'll pay you to show me. And then, we create their own account for them. And, or I have other clients that don't want to deal with that. And then I do it for them, but it can get expensive to have lawyers do it, so it's good to know how to do it. It's not that hard. Any other questions?